to the dais and getting my speaker notes, what I used to do is I used to take a blank sheet of paper and I used to write only points which I want to speak during the next 10 minutes. So let's say if I get deviated by a question, or if I get distracted by somewhat answers, I can always just look back to my blank paper and I can realize that, okay, this is the point which I'm going to speak. And another thing, never ever read out from your speech, because if you do that, you will never be marked highly. So please remember that. Any other question you have for me? Any questions? Yes.
For me, here will be first answer. And this type of policy arguments will support me.
Which type of
policy arguments will support me in this matter?
I'm not able to understand which type of policy matter.
Policy arguments.
Okay. Arguments. So see, again, your arguments depends on your mood. Exactly, right? So let's say if your proposition revolves around, have you guys heard about CISG? Anyone? Let's come back to Constitution. You have read somewhat Constitution, right? So let's say your submissions in regarding to Article 19(1)(g), that is restriction on trade and profession. So how your submissions or your arguments have to be, you first have to establish that the particular problem, let's say today the question is whether prostitution comes within 19(1)(g). So the first thing which you would have to prove is that the prostitution comes under trade or profession under Article 19(1)(g). Then you have to say that whatever restrictions are there on, let's say, prostitution, they do not come under the reasonable restrictions under Article 19 Clause 6. This is how you have to structure a submission, that once you prove A, after you have proven A, you come to B, and then you come to C. So this is what a structure is, right? So if I'm a judge and I'm listening to your arguments, I will make bullet points that she had also dealt with this point, and this point. That is how I will mark you. So the best way to understand how you should divide your submissions, or how you should draft your memorial is, if you have a legal proposition, divide it into as much minute points as you can, because that will help you in making a more structured and more simplified submissions before the judge. Does that answer? Anyone else?
Actually, we have certain students that join online.
Okay.
So one question is from Pratap Singh. He wants to know that is there any chance of judges being biased?
Yes, absolutely yes. But I will tell you what kind of bias you are talking about. So I think you will learn about it in one of your subjects. We learned about biases, I think, in our political science or in psychology. Exactly. So how biases work is, let's say I am from NUSRL and I see a team from NUSRL before me. Obviously, I will be biased. So therefore, usually in this case, the judges are required to write in the conflict of interest wala area that I will not judge any round when my own team is there. But now there is also another kind of a bias. Let's say if I see that let me give you an example of bias. So usually, I will be very honest, we have faced judges who we saw were very biased, maybe towards the opposing team, or maybe who just had some sort of an issue with us for absolutely no reason at all. But again, as I said, while you will have judges who might be prejudiced towards you or who will not be prejudiced towards you, you still have to answer their questions with a smile on your face. No matter how angry you are at them, that question kitni baar pooch rahe, they are not letting me complete my submission, they are wasting my time. But even then, you have to keep your voice lower, you cannot raise your voice, you cannot scold the judges. So in one of the moods, I was almost told by a judge that after the point I thought you were scolding me. So I was told this in feedback, I think in my second year, one of the mood, that the judge almost felt that I was scolding them, because I speak fast and I think I raise my voice at time when I get very excited. I think I'm making a very good point. So that judge marked me lower. So the key to entire moot is that no matter how unreasonable question the judge is posing before you, you have to understand that he is going to mark you, she is going to mark you. So poise yourself, take a moment of indulgence if you want, prepare that answer, and then present it in as simplified manner. Now, let's say I'm saying that consideration is not what you say it's there. So even though you have answered my question twice or thrice, even then if I'm not satisfied, maybe you can always answer in this manner, that while I understand the concern of my lord, but I respectfully disagree, and then put your point. But all this have to be in a very respectful tone, because that judge is going to mark you. So control your anger, poise yourself. Do not show that the judge is facing you or is making you scared. Be as calm as you can and always answer with a smile. And trust me, because that adds brownie points always. Anyone else? Any questions? Is this question by Aruni Singh?
No, ma'am, this question was from Pratap Singh.
Okay.
Okay, ma'am, we have one more question from Ayushi. She wants to know how important is vocabulary in memorial and will it affect our presentation?
See, again, vocabulary basic hona chahiye, and if as this is not an oratory competition, which I've said repeated times, your submissions must include legal points. For example, any layman can say today, let's say what happened in COVID. Almost all the transactions got delayed, shipments got delayed, transportations got delayed. So any layman would tell you that as it was COVID, so things were not in the control of the buyer or the supplier, therefore there was a delay. But as a law student, if you are, let's say, drafting this issue, you will have to use the legal terminology in that. So legal vocabulary is something which is going to help you. You have to use words like force majeure. You have to use words like whether they was reasonably foreseeable or not, whether you could have taken reasonable care or not. So, but if you are well versed with these legal vocabulary, you really don't need to have a very fine vocabulary in English. Trust me.
We have one more question from Nikita Singh. She wants to know what is the correct way to start the research for a moot problem.
So how usually my team used to do it. My team used to do it is, we used to print out the proposition. Now I understand at times the moot propositions might be 50 pages or 70 pages long, but still print it out for the very simple reason is you can go through each and every point like you are, let's say, reading a story or something. Keep your pencil in your hand, make small points. That is the first impression when you were reading the moot proposition for the first time. And trust me, it always helps. We have seen that at times the understanding which we had of the facts that the first time we read was actually the correct understanding. Or at times we realized that was not the correct understanding. But for that, read your proposition as minutely as you can, underline words, underline points, highlight, use different color pens, you discuss with your teammates, but that is how you start with your moot proposition. After that, usually in moots, you are given issues. I don't think now we have any moots where they don't give you issues. So let's say you have 4 issues. So the next part would be that you have to divide those issues among your teammates. That is, let's say if I'm speaker and I have a speaker one, we will divide it like I will deal with 2 issues, you will deal with 2 issues. And let's say we have 1 researcher or we have 2 researchers. So one researcher might help me in my issues, and another researcher might help in their issues. So now let's say once you have that, let's deal with a simple proposition that you have a moot on force majeure. So your next step could be that you will have to understand force majeure, where does it arise under Indian law? So you have Indian Contract Acts for that. So your next part would be read about section 56, read about force majeure, read about hardship. Now, once you have a basic understanding of the concept, then you can move forward to more minute aspect that how does force majeure work in your scenario? Because again, this is not a research paper. The judge does not want you to list everything about force majeure. The judge wants you to use your arguments on force majeure to show whether your client situation comes under that scenario or not. Are you able to follow, everyone? So that is how you start your research. You first start by understanding the concepts, the broad concepts. For example, in NLS Trilegal, we were dealing with blockchains and smart contracts. We had absolutely no idea about it. So we literally Googled what is blockchain, what are smart contracts, how does that work? Because once you have an understanding of the broad concepts, only then you can go to the minute aspects, right? There is no harm in just Googling stuff randomly so that you have a finite understanding of the concept. And then you move forward with your research. You move forward with researching on case laws, move forward with researching on articles or interpretations of particular provisions if you have those, and that is how you proceed. I will just call my next speaker with just this one point. So in my interview, one of my interviews, we were asked this question. I think the judge there had done, not the judge, I'm so sorry. The partner who was interviewing me had also done WIS. You all must have heard of WIS Hong Kong, WIS Vienna. These are very old moots which have been, I think, going from, I really don't know how long, but a very, very long time. So that judge had also done that moot. And the first thing which that partner asked me when I sat for that interview was, what were the issues you dealt with in your best mood. So why I'm telling you this is, moods, good moods really add on to your CV, but only those moods add on to your CV in which you have actually worked. Because let's say if I had not worked on this, I would have never been able to answer the question of that partner. I would have just given him some vague answers that, yeah, it was something about contracts. But he expected me to know the exact issue. He expected me to remember those exact issues in which I spoke about. So understand, do good moods, do challenging moods, and do it with great teams or good teams who you can shout on. That's the criteria. You have to make teams with those people who, if you even shout at, they will not be angry with you and they will continue working with you. So therefore, please be very, very vigilant in choosing your teammates and your moods. Don't go for moods which have a large pool, which from your alumni or from your seniors or from people which have done those moods, that their organization might be little biased, might not be biased. For example, I know moods, I will not name them, where usually the host college only wins. So why would you want to go for that mood then, right? So easily research on moods before you apply for them in your allotment. So once you do that, you will know that at least even if you lose, you did not lose in a mood where the organization was bad, or where the judges were biased, or the organization itself was biased. I guess that's it, guys. 3 things: question bank, be articulate your sentences. This is not a speech competition, and simplify your submissions and make a structure. That's it. Thank you.
Thank you so much, ma'am. Welcoming our second speaker, Sakshi Sharma, ma'am, who has received honorable mention for David Hunter Award for Best Claimant Memorandum 18th William C. West East Moot 2021. Participated in International Commercial Arbitration Cross-Examination Moot 2021, organized by Science Expo University. Finished as 10th finalist and secured 4th Best Claimant Memorandum 12th Analyst Trilegal International Arbitration Moot 2019. Finalized as second runners-up 12th Nalsar Justice B.R. Shawnee Memorial National Moot Court Competition 2018 and adjudged as second best researcher 12th Nalsar Justice B.R. Shawnee Memorial Moot Court Competition 2018. I welcome you on the stage, ma'am.
Hi, good morning, everyone. Am I audible? Yeah. So I think Hetal has covered most of the points that you wanted to know about the mood preparation and everything. I will just talk about the experiences. Yeah. So I will just talk about the experiences. So one thing that most of us have a myth about is that if you're doing moods, you have to compromise on other aspects of the law college, which is not the case. You have to focus on everything that is there in the college. For example, as Hetal was telling you that we are asked questions about the basics of contracts, basics of the laws that we are dealing with in the moot court competition. So for that, it is very important that we focus on the subjects that we are taught in the class. So for that, it's very important that we balance everything that is going on in our law school. So you can't just go on doing moods and compromise on doing anything else. For example, you can't leave classes. You can't do bad in academics. You have to do well on academics as well, because that is the only thing that will help you in answering the questions in moods. And as Hetal was telling about the research, how you start researching. So first of all, that she was telling that you have to read the preposition as many times as you can. So once you start researching, just take the printout of the mood preposition and just give it some days. Don't think about anything else. Don't start researching right away. Just start reading about it. Just go on reading and reading the mood preposition as much as you can. If you have a lot of time, then of course devote it a week or as per how much time you have. Just devote it a lot of time, read about it, and go on reading, make points, and write what as per your understanding should be the arguments for that, and then go on researching for the legal points on that. Because there is no set procedure or a set process that you have to follow. Each team follows its own process. Each team has its own way of approaching a moot. Because for example, in the first moot that we went, it was based on Aadhaar, I guess. So we had a lot of, we got a lot of annexures printed out. We had a trolley bag full of annexures. We submitted a lot of annexures, although it impressed the judges quite well. But we ended up getting eliminated in the preliminary rounds. They were like that, yes, we know that you have prepared really well. You had very intimidating entrance that you made. You had a trolley bag full of annexures, and you were very well coordinated among your teammates. But ultimately, what we are focusing on is the legal arguments, and not the other aspects of anything that you are presenting here. So from that note, we realized that even preparing a memorial and presenting it are two different things. So for Biasane, we prepared a memorial, and we had a totally different set of arguments, not a different set of arguments, but a totally different pattern of arguments that we are following. So once the even the Moot memorial submission has been done, the next thing begins is the preparation of the oral arguments. You can't just go on reading the arguments. Although I have not been the speaker, but the way we have approached all the moots is that we prepare our memorial, we submit it, and then we start preparing for the oral arguments, and we make another summary sort of, and another set of arguments that we are going to follow. Because if you try to stick to the memorial, you don't have a lot of time there. You just get I think 15 to 20 minutes to present your arguments, and you can't cover everything that is there in your memorial. You have to focus on the legal aspects, on the important points of there. And I think for the orators, for the speakers, the most important thing is the spontaneity, which has helped them a lot. Because in a lot of moods, you won't be able to stick to your arguments. The judge will take you somewhere from. You won't even be able to recite even one line which is there in your written submissions. So it's very important that you're well versed with the law, with the legal framework that is being followed in your moot prepositions, and whatever is there in the moots submissions. You have to, of course, know everything that is there in your written submissions. But it is also important that you know the facts well, you know the case preposition very well, and you are able to answer everything on the facts, on the issues, on the legal points, and not just your legal points. For example, the speaker too has to know everything that is there in the submissions of the speaker one. Because a lot of times, I think in the BR Sane quarterfinal rounds, she was asked a question about something which was there in the speaker one's arguments. But she was able to answer that because we had discussed it so many times. We had given each other a lot of opinions on everyone's issues. And that's why it's very important that you don't just that if even if you have divided the issues, it's very important that you are coordinated well. You know everyone's issues, and as a researcher, it's very important that you make the job of your speakers easier. So a lot of times it used to happen that we had to submit a lot of annexures, a lot of compendiums, but it's not possible for the speaker to remember everything because they are making their submissions. They can't just make a reference. So what I used to do is that they used to cite some case, and I used to refer to the compendium. I used to submit it to the desk because we were so much coordinated that we remembered what needs to go on each point. So that's why it's very important that you coordinate with each other. You don't just work in isolation with your teammates, because ultimately it's a teamwork, and you have to have a very good coordination. So do you have any particular questions about the mooting experience or anything about researching or making memorial submissions? Anyone? Let me know if I'm going fast. I am, I guess. All right. Yeah. So it's the thing that you grow with each mood. In the first mood, we had a totally different experience. We had a totally different ideology. We were like, we have to look intimidating. We have to go with a trolley bag full of annexures. But in the second mood, we were like, okay, keep it minimalistic. We will just go with the necessary annexures, necessary printouts, and we'll just go there and we'll just focus on the legal points. And it was very important for us to realize after our first mood that articulation is what we need, and we can't just go on reciting our memorial what is written in there. Our seniors told a lot of things, but I think we developed our own strategies with each mood. For example, in NLSTIM, we had 3 months to prepare, but when we were preparing for this, we were allotted the mood just 10 days before the claimant's memorandum was due. So we just had 10 days. We were not able to read the proposition. For example, just as I was telling you, that read the proposition as much as you can, read it, give it 10 days. But for this one, we just had 10 days to even write our submissions and just give it away. So what was important is that we get into that pace and just develop another strategy to prepare that memorandum. We took 10 days, and I think even on the day of submissions, we were still arguing about some points that, I don't think this is the correct understanding. And ultimately, we ended up reaching a conclusion and writing the correct things that were there in the that were required in the shoes. So it was all possible because we gave each other that much space to raise their arguments. And it's not just that the speaker cannot give their opinions on this legal issue, the researcher cannot. No, everyone's opinion has to be respected in a team. And because we kept arguing on a lot of points, and that's why we came to a conclusion, this is the correct legal understanding of this particular issue. And I think that's the only way you can succeed in any moot court competition. I don't know if a lot of times that understanding may be completely incorrect, but that's the understanding of a team. And you then whatever happens, you can't blame the speakers that, even if you're losing or winning a moot, it's a teamwork. It's not the responsibility of one person to take you there or to and win it. You all have to give your 100% to it. And I think it's very important to define roles in a team. Although you have to coordinate with each other, but of course you have to define roles. You have to have a set understanding that this is the job of this person, this is the job of that person. And I think that's very important to understand from the beginning, right when you have been allotted that move. And uh, yeah, and of course that happens only after 2-3 modes, and you gradually develop your own process or your own procedure. And also I think modes don't just help you professionally, they also help you a lot personally. Because I think my closest friends are my teammates right now, and we have all been doing modes since first semester. We have all been a part of the same team, and I think that is going to stay with us. And we are going to be able to discuss even when we start working. We will be able to call the other person, that I don't understand this particular point, I need your help with this. Because that has been the kind of relationship that we have shared all these 5 years. We were not shy of not knowing anything, because one person knew something on some point, and we knew something on some point. So we all shared our understanding, all shared our experiences, and we were able to reach where we have. I think these people did a few more moods than I did, because I left for I think 2-3 moods in the middle. But then when we were doing this, so my team was insisting that we are not going to do this mood without you, because this is probably going to be our
So moving forward, I would like to call up our next speaker, Ayush Chaturvedi sir, who has secured second runners-up position in world rounds of 13 Frankfurt Investment Arbitration Moot Court 2021. Participated in International Commercial Arbitration Cross-Examination Moot 2021 organized by Sciences Po University. Awarded honorable mention for best memorandum on behalf of claimant in 18th William C. East Moot, Hong Kong 2021. His team has been ranked amongst top 3 teams to qualify for the national rounds of 13th Frankfurt Investment Arbitration Moot Court 2021. He has secured fifth best respondent memorandum in world round of 11th Leiden Sarin International Moot Court Competition 2020. He has secured third rank and third best memorandum in national rounds of 11th Leiden Sarin International Moot Court Competition 2020. He has secured 10th finalist position and fourth best claimant memorandum in 12th NLS Legal International Arbitration Moot 2019. He has secured 8th position in national rounds of 4th Professor N.R. Madhava Menon Sark Law Mooting Competition 2018. I welcome you, sir, on the stage.
Hello, can you hear me all? Thank you so much for the to the university admission for inviting me, and a special thanks to Mayank sir for hosting us. Before I proceed to sharing my experience, I would like to acknowledge that the inclusion of word tripod in the theme, and I understand that whoever has framed the three basic tripods has done really a great job. So before because I think research drafting and oral presentation are three most important parts. If you do all these three right, there is a chance, and I stress upon the word chance, that you are going to fetch a citation to your university. And before I discuss my experience with how three tripods of the mooting, I would want to know how many first year, second year, or third year students are there here. Can we have a quick raise of hand? Because what I'm going to, all right, thanks. Because what I'm going to discuss is going to be very important and helpful for the first, second, and third year students. Probably because fourth and fifth year won't have the chance to, because we share almost the same age and same experience, we won't have much chance to implement what I'm going to here to say. With respect to research, I would want you to first understand that this is probably the biggest mistake that any participant or person who is going to like judge the moot, or somebody who is going to pose the moot is going to make, is not be well versed with the proposition. I want you to understand that once you have been allotted a moot, I'm not sure what is the process of allotment of the moot. Let's say once you choose, let's say, constitution moot, once you're allotted the moot, as my previous speakers have stressed, that you have to take a printout. That's the necessary thing. And once you take the printout, you are going to be well versed about it from the first word to the last word. So how I go about it is, first I look at the issues. Probably I don't think there are this is probably standard format in Indian moots as well as in international moots, that they provide you the issues beforehand. And if they do, you have to first go through the issues, because once you just read it, you won't understand a single word. But once you download once you like look at the proposition, first go to the last page and read the issues. Once you do that, you won't understand a single thing. Just write it down on a paper and start reading from the first word. That is the first paragraph. Understand that I have seen the teams. I have previously participated in the moots, have judged the moots, have coached the moot, have coached the teams, and I know that there are teams which make the mistake of not going through the first or second para, or ignoring what is written there, because it's an introductory para. It sets who are the parties of the, let's say, particular let's say in constitutional moots. It will tell who is the person who has been violated, or let's say fundamental right question. It will tell the person in question. And there are a lot of teams who make the mistake of not going through the first para or second para. They do not focus about that. Now, I really want you to acknowledge that and understand it very well, that going through the proposition, each, let's say, if you participate in a good mood, each and every word that has been given in the proposition holds a value, holds an importance. It's there for a reason. And understand this, is the relevance and everything. And once you do that, proceed on to understanding the issues. Let's say, as I told you, that this is a standard process in national, international moots, that they provide you a brief overview of, let's say, they generally previously frame the questions. Even though you want to have a better understanding of what are the sub issues, let's say you are proceeding to a constitution moot, and there is a question about violation of fundamental rights. Then before you establish that there has been a fundamental rights violation, you want to establish that it has been done by a state, right? Because enforceability of fundamental rights is premised upon, if is possible only if the defendant is a state, or the, let's say, violator is a state. So understand it, because and I wish to highlight the logical coherency of the argument in that sense. Once you read the proposition, you will know how the facts are given in the particular proposition. And with respect to this is the research part I'm highlighting. So first, read the proposition very well. Each and every word is important. And once you do that, it is very important to look at the background of the law that is being, let's say, constitution. If there is a contract moot and you are being talked about force majeure, then you have to know the position of law in the Indian Contracts Act. What are the reasons behind it? How it is imposed? What is the position that is different from the common law? Or these the general background of the on what basis the proposition has been premised. Now, once you like focus on the research aspect and the like two tasks are done. One, you have read the proposition very well. Secondly, you have focused on the legal aspect. How you have read the legal background on which the proposition is premised. Now you would want to understand that what is the core law that is being applied, and what is, let's say, you are generally, this happens in national mode, that there is some court involved, or there is some forum involved on which the doctrine of precedence applied, the doctrine of stare decisis applied. Now generally this happens in, so situation of national mode is very different from international mode, in the sense that national mode more focuses upon, basically we as a common law country focus more upon the legality aspect, the legal law aspect, while the foreign, in international mode, if you are going to participate, you will observe that the teams that have arrived from civil law countries, and the judges who have like practicing as an international advocates, are much focused upon the relation between facts and law. So they do not focus much upon the binding aspect. Otherwise, they focus upon why the particular law has come into force and what is the reasoning behind it. But in national modes, let's say you have been asked whether a particular judgment is binding on the court, and you are, let's say, appearing before the High Court, and you said that this judgment is from the Supreme Court. They are not going to question it. They are going to absolutely accept it. That is the doctrine of stare decisis. So that is difference between how we are going to. So I participated in one national mode, that is Sakla mode, and Madhav Menon Sakla mode, 2018 edition, in which so that was only national mode that I did, and after that I went to I only did international modes. So I observed this common feature of focusing more on the law aspect. So once you have read the proposition and read the background and read the I think the legal aspect, you are good to go. And the next point that I'm going to highlight is the drafting part. Now, before, one of the biggest mistake that I have seen people doing, and in my first year, I also did that, and Mayank sir would agree to that. He was he was my contract teacher in first semester, and I did very bad at that. So the mistake that I did was I highlighted the law and I wanted to tell the judge what the law is. That is the biggest mistake you can do. So in that sense, you have to frame your argument. You have to frame your submissions and write the memorandum in a way that it is argumentative and not explanatory. So I hope you understand the difference between argumentative and explanatory. Because in argumentative, what generally happens is there are basically 2 or 3 premises upon which you want to draw conclusion. Because but while in the explanatory memorandums or submissions, you are just explaining, let's say, what Article 19 of the Constitution to a judge, which is not going to go good with the judge. So explaining particular, let's say, provision of law or the any legal point to a judge is not going to very good. And in that sense, I think the biggest lesson that you can learn from here is that you have to frame a particular point or a particular submission while drafting a memorandum. Is you are going to frame it very argumentatively, not going to frame it very let's say explanatory. Another point that I want to make here is with respect to identifying of the sub issues. I'm not going to talk about identify because most of the national modes or international modes do that beforehand. But ultimately, even if you are provided with if you are provided with let's say 2 or 3 questions before, you are not going to understand it, or you are not going to make a proper submission before the court if you are not very well versed with the identifying the issues. So once you read the proposition and understand the background in which the legal proposition has been framed, I think the next step is to identify the issues or sub issues as the case may be. And once you do that, let's say in jurisdiction, people generally miss that the particular forum. One of the major submissions that I have seen people missing is that the particular forum that you have approached is has efficient remedy. So this is one of the most ignored sub issues in the jurisdiction part. Or let's say, as I cited example before, that once you are focusing on, let's say you are dealing with the issue of violation of fundamental right, then first the and foremost point that you are required to prove that the violator is a state. This is how you have to proceed. So do not miss upon the issues. That is first draft the argument very, let's say, in very argumentative manner. Secondly, do not miss upon the sub issues or identify it well. Third is the oral presentation. I think Hitil and Sakshi have already covered this issue. That while I think my biggest question with the oral presentation is that whatever you are doing, so understand that the, as I highlighted before, that there are three legs of the tripod. So you have already covered two legs. So understand this, that 60, let's say if you divide this in percentage, 66% of the moat you have already prepared, but the other 33% that is left is going to be very crucial. Because if you are going to, if you are going to a moat without preparing what is done, you are going to absolutely lose it. But if you are already prepared with 66%, but you are not going to use it in your oral submissions or oral presentation, you are absolutely going to lose it, and you won't get any citation. Because your research, there is a chance that your research will get noticed and you will get let's say best memorandum or second best memorandum award from the side, from either side. But there is chance that if you perform well, I remember when I was in second year, a team of Hetal, Sakshi won, I think were runners up in the BR Sani moot court competition. It was great. So I was not part of the team, but it was great to have somebody from our batch in the second year representing to a prestigious national moot court competition. And they did not only they were not only the runners up of the competition, but they also Sakshi faced the best speaker, if I'm not best researcher citation, and Hital faced I think second best speaker citation. So you can, like, once you go to the mood, there are a lot of possibilities, there are lots of rewards you can win. And I think you can equally divide 33% weightage to all the issues. While making the oral submissions, I would recommend all the three members, be it speaker or be it researcher, to like think on their feet. Because ultimately I think the biggest fear of everybody, like every speaker, is that they are not going to understand the question of the judge. So it is very important that you understand the question of the judge. And ultimately I think if let's say you are a researcher and your speaker is not focusing on particular aspect of law, or is not grabbing the question of the judge, you as a researcher has a duty to pass the shit, if it is allowed, to inform about the correct question or the correct, let's say, citation about the case, anything. Now in oral presentation, I think this is the most important thing, that you think on your feet. Everything that you have read will ultimately help you. And that is why in the research part I have highlighted the second point, which is that you have to know the background of the premise, or the background of the lay proposition on which it is premised. So that's it. Research, drafting, and oral presentation, I think these are the three tripods of the mooting. And once you, and let me, from my experience, what I want to tell you is that there is a high possibility. So firstly, you have to be absolutely true to yourself and true to the team and give your 100%. But even if you, let's say, there is high chance that if you give your 100%, you are going to like fetch at least one citation. But let me tell you this is honestly, that there are number of ways in which you can win a move, or you can win a citation. But there are additional 1,000 number of ways than that in which you can lose a move. So even if you do, let's say, research, drafting, and oral presentation good, this is not going to ensure that you will get a citation, because you might face a bad judge, you might get a best team of the in the competition you may be up against. But keep the hopes up and try to do your best. Because I think one of the more words that I want to focus here is the journey. Because it's all a journey. You are going to learn, despite the fact that you are going to lose or win. I think I have lost a couple of moods, and I have won a couple of moods at international level. What I want to tell you from my experience is that the skills that you gain during the research and the drafting is going to help you at higher stage. Let's say you are going to utilize that particular skill at higher, with, let's say, with a prestigious bench or with prestigious board of academicians in a particular competition as you go up. But otherwise, I think preliminary round is the time where you gain most of the experiences. And now I would like to like people from the first year, student from first year, second year, third year, to specifically question on these three aspects. And as I think I'm a final speaker Let me know if you have any questions. Anybody, is everybody aware about how to like proceed with the research and drafting and oral presentation? So that depends. I would say that depends upon like the mood you are participating. Let's say you can understand this. Let's say proposition is of 5 pages. I think 50 case law would be enough. Let's say you are only provided with let's say there are two types of like moods that happens. One in which the total word limit or the total page limit of the memorandum is limited, and secondly in which the total page limit of the submissions are limited, excluding like other part, front page, jurisdiction, all other things. So let's say if you are participating in a mood where let's say whole proposition of 5 pages, I think 50 case law would be enough. But let's say if you are participating in a mood where you are provided with a submission page number limit of 20 pages, then I think approx 150 to 200 case law would be good. But rider is the provided. I am saying this provided you do not cite case. Let's say you are provided with a proposition which is very new in its sense. Let's say we participated in endless triangle international commercial arbitration mode, in which we were provided with case law on the subject matter of blockchain technology, where we needed to differentiate between blockchain technology and Ricardian contract. So there were not many case law in the India. I think this was 2019 when we participated, and post pre-COVID, the blockchain did not develop that much, and we did not have case law on the legality aspect and how it was implemented in the commercial contracts. So ultimately, that depends. Do not cite case law, cite like reasonable number of case law, but do not cite overly or like more than what is required. Any other question? Yeah, please. Okay. Okay. Right. Right. How to proceed about it? So what subjects have you read till now? Have you read torts? Let's say there is a certain, let's say strict liability, that you get a proposition on strict liability, right? Firstly, and you are arguing for the, let's say, defendant from that side. It is very important that you first refute what are the essential elements of the how you focus upon particular proposition. Is that you have to understand that whatever is being questioned has some essential ingredients, right? If you are if you are establishing force majeure, right, there must be some essential ingredients in that, right? That demand must be contemplated, or that must be foreseen by the parties. There must be a clause in the contract saying so, right? Once you establish, let's say you are arguing from the side of petitioner, or you are arguing from the side of plaintiff, you have to firstly establish the essential ingredients, right? And let's say once you have done that, and you are arguing from the side of defendant, apart from refuting the essential ingredients that particular, let's say strict liability is not applicable in this case, you have to also plead for defenses, right? There are certain defenses available to the strict liability, and once you have refuted the essential ingredients of strict liability, you have to go on to plead the defenses. That is how you proceed. First, ingredients of that issue. That is sub issue. What are the sub issues? Once you have done that, you plead from the side of petitioner. If you're pleading from the side of plaintiff, establish that issue. If you are refuting from the side of defendant, refute that issue. As simple as that. That does answer your query. Any other question? Thank you so much.
Thank you so much, sir. Now I would request Ananya ma'am for the momentum. I would like to request Ananya ma'am to present the memento to our speakers. you, ma'am. Thank you, sir. I would like to extend my heartfelt gratitude to all the speakers who now I would like to call upon the stage Tuhina ma'am, Assistant Professor of Amity University, Jharkhand, to deliver the vote of thanks.
So good morning, one and all. Warm greetings from my end to this August gathering on the second and the last day of the National Workshop on Embarking a Moot Journey, the quintessential tripod of research, drafting, and oral presentation. I, Ms. Tuhina Sinha, Assistant Professor Law, Amity University, Jharkhand, extend my heartfelt gratitude to all the participants and for this event across the country and my dear students of Amity Law School. So on the behalf of Amity Law School and the entire Amity University Jharkhand, hereby I feel so much proud to host my own university students and very much heartfelt gratitude to all the students of NUSRL, that is Dakshi, Ayush Chaturvedi and Sakshi Sharma, who have came here to share their experience for their national as well as certain international moot courts competition. And we all thank you, you three, for sharing your journey with us. That will surely help and guide our students to avoid some of the pitfalls that would possibly lie ahead in their journey, and for sharing your journey and experience, which will also surely inspire and motivate our students of Amity Law School and the other participants who have been participating from different parts of the country. Now, certainly this second day, this 2 days national workshop or the event till now has been very much useful for all of us, as we got the opportunity to make ourselves aware about some unique perspectives and practical experiences to the most pertinent question relating to the contemporary issues on moot court competition. Now, last but not the least, a very happy and enriching learning to all the participants of the Amity Law School and outside. Now, on this note, I would seek permission from this August gathering to allow me to proceed with the valedictory ceremony. Thank you.
Thank you, ma'am. Thank you to everyone who made this session enrich. I extend my gratitude to everyone present here. Now we'll move on to a shorter one.
और डॉक्टर गिरजेश शुक्ला
ओके स्पीकर जैसे सुबोध शाह थे, अश्मिता बिसारिया और गिरजेश शुक्ला,
मतलब ये तो चीफ और चीफ गेस्ट
थे बस। ठीक है, तो इन्होंने ये सब बताया ना,
सारों ने ये सब बताया।
और आज का तो चलो
इसको देख के बोलना है इसमें से। प्रिंट आउट नहीं है
ना,
प्रिंट आउट फटाफट ले लो। ये लैपटॉप का आवाज कहीं और जा रहा है ना इससे।
ये मैं ओपन नहीं कर सकती, बोल रहा है
आपको फोन पे भेज दे।
ऑपरेट करना होगा फिर अपने हिसाब से। लॉगिन करके जूम में लॉगिन करके पहले मेरे को करने दोगे तभी हम कुछ को बता पाएंगे, नहीं बता पाएंगे। अरे नहीं,
A very warm good afternoon and all present here, and welcome to this valedictory session of two-day national workshop on embarking a mood journey, the quintessential of the tripod of research, drafting, and oral presentation. For this session, we have among us our guest of honor, Honorable Mr. Justice Anand Tiwari sir, former Judge, High Court of Jharkhand, our guest speaker, Mr. Bhavesh Kumar sir, Advocate, High Court of Jharkhand, Honorable Vice Chancellor sir, respected Director sir, respected Registrar sir, and Kasturi ma'am to honor this session. Light is a symbol of brightness and prosperity. As sunlight expels the darkness, similarly, blessings brings us in our life prosperity and happiness. To make this event a more blessed one, let's invoke Goddess Saraswati by kindling the lamp of knowledge and wisdom. For seeking the choicest blessing, I invite our guest of honor, our guest speaker, Vice Chancellor sir, respected Director sir, respected Registrar sir, and Kasturi ma'am to kindle the lamp. And I also call upon Richa Priya, student Amity Law School, to sing the Saraswati Bandana.
तत्सवितुर्वरेण्यं भर्गो देवस्य धीमहि धियो यो नः प्रचोदयात्। ॐ भूर्भुवः स्वः तत्सवितुर्वरेण्यं भर्गो देवस्य धीमहि धियो यो नः प्रचोदयात्। वरदे वीणावादिनी वरदे वीणावादिनी वरदे स्वतंत्र रव अमृत मंत्र प्रिय स्वतंत्र रव अमृत मंत्र नव भारत में भर दे माँ, भारत में भर दे माँ, वरदे वीणावादिनी।
Thank you so much, sir. Thank you, ma'am, and thank you, Richa. I would now like to invite Honorable Vice Chancellor sir to please felicitate our guest of honor, Honorable Justice Mr. Anand Tiwari sir. So, to felicitate the guest of honor. Thank you so much, sir, for sparing your valuable time and joining us here today. I would now like to request respected Director sir to please felicitate our guest speaker, Mr. Bhavesh Kumar sir, Advocate, High Court of Jharkhand. Thank you so much, sir. To begin with, we have Dr. Kasturi Sahai ma'am, Assistant Director of Law and Management, Amity University, Jharkhand. Having completed her education from Delhi University and VIT Mishra, Ranchi, she has more than 13 years of corporate and teaching experience. She has worked with IBM India Private Limited as SAP ABAP developer before pursuing her research interest. Her doctoral thesis was on the topic, a comparison of traditional leadership and virtual leadership, special reference to Indian IT industry. Her areas of expertise are virtual leadership, quantitative management, and research methodology. She has published many research papers on various facets of virtual leadership and managing virtual teams in Scopus Index Journal, and has presented during international conferences across the globe. She has also a book on leading virtual teams to her credit. She has one copyright and one Indian patent published. She has successfully completed a CSR project on renovation and upliftment of government girls' school in Ranchi district under the banner of Amity. She has received many awards for her contribution in the field of. Ma'am, I request you to please come on stage and give the welcome address.
A very good afternoon to Honorable Mr. Justice N.N. Tiwari, sir, and our expert speaker for the day, Mr. Bhavesh Kumar, sir, Honorable DC, sir, respected Director, sir, and respected Registrar, sir, all the law faculties and my dear students. It is an honor and privilege for me to welcome you all to the national workshop which is being organized by Moot Court Association for last 2 days. And we had some very knowledge enriching sessions yesterday and today itself. And on behalf of Amity University, Jharkhand, I once again welcome our Honorable Justice, sir, and our expert speaker for the day.
Thank you so much, ma'am. We are grateful to have with us respected Registrar, sir, Mr. Prabhakar Tripathi from Amity University, Jharkhand. Being a teacher by profession, he is well acquainted with students' perspective and prospects. Throughout his professional career, he has been only in education department and started his career as a teacher, and by virtue of his dedicated services, he got continuous promotions to various senior and responsible positions, that is vice principal, principal, assistant registrar, registrar, group of institutions, and registrar of universities in various reputed organizations in MP, Madhya Pradesh, Chhattisgarh, Uttar Pradesh, and now in Amity University, Jharkhand. Out of his more than 27 years of experience, including more than 18 years of educational administration, he has served. He is a part of Amity University, Jharkhand mission to bring Amity a global identity. His qualification includes the best combination of multi-specialization subjects like science, language, education, management, social science, and personal management, and enabling him to monitor the educational affairs and educational administration efficiently. I would now request sir to please say a few words.
Thank you, dear students. I, on behalf of Registrar, I once again welcome our chief guest and his special guest of honor, Honorable Vice Chancellor, sir, respected Director, sir, and all their faculty members and students. Dear students, like in engineering and science subjects, there is a lab. And for the law students, there is only one place, that is a moot court. In the moot court, where you give the finishing of your expertise and which decides your winning career in future. We have seen so many movies which hovers around court also, and I recall one movie, Jolly LLB 2. But that is for the entertainment purpose. The real intelligence and real professional acumen which is displayed by the advocates while defending the case depends on a very diligent efforts and very intelligent acumen before the justice. And I must say that you are going to be a budding advocate as well as future justices. So what you have learned during this 2 days workshop in Moot Court, that is certainly going to contribute to you. And what we are expecting from our MT students that wherever you go, you enjoy and cherish your learning and disseminate the same for the public contribution also and society contribution. So my best wishes to you all, and we would love to see that how you make your contribution and how you make your presence in the society. Thank you, guys.
Thank you so much, sir. Next, we have our respected director, sir, Dr. Ajit Kumar Pandey, sir. He is a seasoned academician and researcher since last 30 years. He defended his doctoral thesis in the field of social science at Patna University. He is dual postgraduate in management and economics and dual graduate in law and economics. He's trained researcher in advanced research methodology by Fulbright USA. As a student of economics, he served at different universities and gained the exposure of teaching in USA, Europe, Africa, Asia. He is a member of editorial board of a couple of coveted research journal and has many research papers and chapters in books and contribution at international conferences and seminars. He is invited speaker for many prestigious universities and institutions. He has been the invitee at roundtable discussion by IFAD and MIF, American Development Bank. In his 30+ years of teaching career, he has served for FDRE and under UNDP and MEA Government of India, and currently is serving the best private university of India, that is Amity University, Jharkhand. I would now like to request respected director sir to share his words of wisdom.
Honorable Justice Mr. Anand Tiwari sir, Honorable Advocate, Jharkhand High Court, Mr. Bhavesh sir, Honorable Vice Chancellor sir, Honorable Registrar sir, and respected members of teaching fraternity and my dear children. You got to know about my academic interests while I was being introduced, but none of them were of your interest. Of your interest, I would like to share with you that there is a movie called Pariksha by Prakash Jha. And if you have seen that movie, you might have seen me being the judge and sending the main protagonist of the movie for 5 years, I think, if I remember correctly, behind the bar. So while playing the role of a judge, I very closely compared how actual court appears to be, what type of dramatized court happens to be. And there is a big difference between the two. Let me tell you, the actual judicial activity happens to be of very grave in nature, very serious sort of things. But when it is a dramatized way of presenting a court, it is quite different. But still, in majority of the film, they try to replicate the actual courtroom, even though they fail. This is my personal observation. And when they fail, they miss so many things which we normally call the protocol. You know, judicial service or judiciary is taken as the highest in order when it comes to banking upon for establishing the laws of the land. I would like to remind you about what is happening in Pakistan, in our neighboring state. The deputy speaker, this is a case study for each one of you. The deputy speaker, considering that the ruling government has gone in minority because of the defection of some of their members, suddenly pronounced that motion, no confidence motion, is unconstitutional, and so it is not to be placed, and it was withdrawn. And later on, the Honorable President of Pakistan dissolved the assembly. And this happened just to safeguard the interest of the then Prime Minister, or even we can say even today, the Prime Minister, Mr. Imran Khan. You know, there was a constitutional crisis. If no confidence motion is placed by the opposition, and then it is decided by the Deputy Speaker that this no confidence motion has got some malified intention or some sort of corruption levied against, and so that is why this no confidence motion cannot be accepted in the House, and it was not accepted. You know, this Deputy Speaker's right, whether the Deputy Speaker is competent authority to decide whether this no confidence motion can be placed or not, was challenged in Honorable Supreme Court of Pakistan. And Honorable Supreme Court of Pakistan, full bench, in court number 1, in the presence of Honorable Chief Justice of Pakistan, declared that this was a wrong decision, and quashed all the decisions, all the activities, or all the decisions taken by the government later on, and recalled the assembly that the parliament should be in place, and the parliament is in place. Now the no confidence motion will be moved once again. Now there are so many intricacies inside if you look into, and each and every thing that is happening or that has happened or that will happen is as per the constitution. In a democratic country, the constitution is the soul of the democratic nation. So you cannot go or you cannot do anything which is unconstitutional or which is not as per the constitution. And that requires deep researches, which you have to learn. And you might have learned also. And then you have to practice this as a case, as a fictitious case inside the moot court. You can plead, you can appeal, you can defend as if you are doing the same inside the courtroom. And why I am saying moot court, not the court that we are normally noticing inside the cinema or in the movie. Because moot court happens to be the true replica of the court. Everything that you are doing inside, like while defending or while pleading, you have to have the eye contact with the honorable judge. That shows your confidence. That shows that you are, whatever you are saying with all conviction. Whatever you are saying, you are trying to make honorable judge believe your words. So that way, eye contact should be there. Then it is allowing you to be the best listener, and your opponent, pleader, learned counsel is pleading and you are listening to that. So you are becoming a good listener. So how to listen, what to speak, how to behave inside the court, that is of paramount importance, because this is the temple of the judicial system where you have to practice. So all piousness, all sacred things that we normally do while worshipping our Almighty God, the same thing is to be done there inside the court. So maintaining the order inside the court, maintaining the decorum inside the court, maintaining the protocol inside the court, besides all knowledge that you have acquired while doing your law academics, you have to have the behavioral aspect that you need to understand and that you need to practice. Otherwise, you are of no use. If you are not behaving properly inside the courtroom, you will never succeed. And at the same time, while dishonoring the court, you may put yourself into trouble and you will be put behind the bar for dishonoring the court. So it is that sensitive. Children, it is very sensitive, and that is why we are doing this moot and the mooting sort of activities. and exercises. Each and everything is so important. And during your yesterday's session, you might have heard so many good things, so many experiences. I remember Honorable Mr. Justice Shaha from Gujarat. He was talking about his experience as a judge and as a senior advocate. And he was telling you so many things, that how and what way you should take up the cases inside the court. And I'm pretty sure you might have learned so many good things from the expertise of Honorable Mr. Justice Saha. We are blessed to have yet another Honorable Mr. Justice Tiwari sir with us, and also you are going to have yet another Honorable Justice Mr. Mangal Murthy sir on 11th. So all they are, I mean, you are so lucky that you are getting everything from the horse's mouth. They are going to share their experience, and they are going to enrich you, which no book is going to give you that sort of information. So please pay attention to each and every word and try to inculcate each and everything that is being asked for. I wish each one of you all the best, not only for your academics, but the best of your legal profession. Thank you very much. Have a nice day.
Thank you so much, sir. I would now like to invite our Honorable Vice Chancellor, Dr. Raman Kumar Jha, sir. He has completed his PhD in Physics and Philosophy from the University of Delhi. He was a professor and Dean of Academics of Student Affairs in Manipal University of Technology. He has also served as ex-principal of Surendra Institute of Engineering and Management at Siliguri, and has also acted as ex-vice chancellor in Indus International University. So I request you to please address the audience.
Thank you very much. Honorable Justice Mr. Anand Tiwari, sir. Senior Advocate in High Court, Bhavesh ji, with whom I've spent 2 days outside with family, and still he could not come to our university as a speaker for the last 4 years. I regret, but that he's here today will have the benefits. Knowledge, truth, and bliss. These are all that we desire. And it is the Supreme Court or the judiciary as a whole which sits ahead of everything so that truth is not violated, knowledge is always respected, and you are peaceful or blissful with whatever results you get from the Supreme Court. And that's the essence of everything. I have no connect with law per se, as far as education is concerned. But still you have to have the knowledge of all the laws related to anything and everything you do in your life. That is how law is all encompassing. That is, it is going to affect everyone who is alive, including the humans, trees, the environment as a whole. So there are laws which govern everything which is around us. So we just cannot be unaware of things around or the law around. If you are not aware, still you can be booked under that law, even if you are not aware of it. So being aware is one part. So we have to have the knowledge of law and the area that you want to expertise in, get into it, get into details, understand. If you're knowledgeable, if you have the grip of the subject, the confidence comes. And then when you're in a moot court or the place where you have to show your talent to justify the case that you are fighting, it'll come when you are with the truth. Automatically it comes. And then there are clauses, there are articles which come your way to help you and win the case. I would only request the whole law fraternity and would like to hear from our honorable chief guest today. A justification for citing a person who has done really wrong by lawyers is not understood by me. I hope you understand the question. Any case is coming, naturally one is a victim, another is a person who is a real convict, even though not proved. And then we have lawyers fighting for both. How is it justified? Or if the person who has committed a crime is, say, punished, should the lawyer citing him also not be punished? Very difficult question. Only one answer can be, till the time he's not a convict, I think he's a normal person. But then possible delay in this has led us to a society wherein we don't even want to go to the court. So who takes that responsibility, whether legislation or judiciary or people like us who try and interpret in our own ways? But their law interpretation is left to the judiciary, and they are the highest set of people. I only wish our students someday within my tenure here become a judge somewhere around, and I salute him for the knowledge and the truth that he has stood with and grabbed the position to do real justice for the society. Thank you very much for coming. Thank you.
Thank you, sir. Next, we have Ananya Bhardwaj ma'am, who is an assistant professor at Amity School of Law. She is presently pursuing her PhD from KIT University in law relating to copyright. Earlier, she was working as a research associate in Competition Commission of India under Ministry of Corporate Affairs. Before that, she was working as a faculty at School of Law, KIT. She is a BBA LLB graduate and has completed her LLM with a university gold medal from National Law University of Odisha. She has been a part of more than 50 national and international MUNs and debate competitions, and she has also completed her UGC NET. She has been the chief advisor of IDIA MUN 2020 and also served as Secretary General of 3 more United Nations conferences. She has also several articles published in various national and international journals. Ma'am, please brief us about this 2 days national workshop we have had till now.
For the kind words in front of all this august gathering. A warm greeting to all of you on this last day of our national workshop. I extend my gratitude and to our guest of honor, Justice N.M. Tiwari sir, our guest speaker, Advocate Bhavesh Kumar sir, our respected VC sir, Registrar sir and Director sir, and Kasturi Sam ma'am, and all my students present over here. I'm here to brief about what exactly happened in these yesterday and today workshop. So for this, we had a moot court proposal framed, which was a very beautiful case of mooting on contracts law of contracts. And we had with us yesterday Justice Subodh Shah and Dr. Girjesh Sukla sir and Advocate Ashmita Bisharia ma'am, who were the judges for the moot court rounds. We had our students, second year and third year students, present the petitioner and the respondent memorial. Basically, it was both the sides of the arguments that were presented for the case. And then the judges, they clarified some points on how exactly a moot court happens and how our students and the students across the globe who were a part of the live streaming could benefit from the same workshop. So they discussed on how to draft a memorial, what sources can be used, what are the primary sources of research, what are the secondary sources of research, how your attitude should be, how your body language should be while you're mooting, and also the various courtroom etiquettes that are very important for a budding lawyer were talked about. And today we had 3 young minds from MUN who joined us, and they have been a part of various national and international moot court competition. So they shared their personal experience with our students and how they could learn from their pitfalls and the shortcomings that they faced while they were preparing for the moot court competition. So I'm definitely sure that the workshop that was organized by the Moot Court Association of Amity Law School was definitely a big learning experience for all the students, especially for the first years. Thank you, sir. Thank you all.
Thank you, ma'am. Next, I would like to introduce our guest speaker, Mr. Bhavesh Kumar sir, who is a reputed advocate with an experience of 26 years of practice in legal field. He accesses his proficiency in High Court of Jharkhand, Supreme Court of India, and other legal forums. He has completed his bachelor's degree in law from Patna Law College, Patna University, and has been felicitated with National Youth Award by the Government of India for rendering outstanding work in the field. Government of India for rendering outstanding work in the field of national development and social service during his college days. He is also the author of the book on Jharkhand Panchayat laws published by Rajpal and Sons and a commentary on Jharkhand Panchayat Raj Act and other Panchayat laws. He has experience in conducting cases on behalf of the Governor, Chancellor of Universities of State of Jharkhand, Ranchi University, Jharkhand Technical University, Jharkhand High Court Legal Services Committee, and JHALSA, and as standing counsel for the State of Jharkhand, retail advocate and senior counsel of Jharkhand Mineral Area Development Authority, senior counsel for State Election Commission, Human Rights Commission, Jharkhand Staff Selection Commission, Jharkhand State Electricity Board, Ranchi Regional Development Authority, Jharkhand Renewable Energy Development Agency, and Steel Authority of India. He has settled thousands of cases on pro bono basis through JALSA and on individual basis. He is also the head of B. Kumar and Associates, which is an association of high-profile advocates, legal practitioners, and consultants. So it's an honor to have you among us here today. Please welcome him with a huge round of applause.
लोग रजत शर्मा का शो देखा करते हैं, बड़े रिसर्च के साथ रजत शर्मा आते हैं। मुझे पता ही नहीं था कि आपने इतना रिसर्च किया हो हमारे बारे में। चलिए, आदरणीय ऑनरेबल मिस्टर जस्टिस एनएन तिवारी, हमारे अभिभावक और गुरुदेव भी रहे, आदरणीय वाइस चांसलर एमिटी यूनिवर्सिटी श्री झा सर, आदरणीय डायरेक्टर सर, आदरणीय रजिस्ट्रार सर त्रिपाठी सर, मुझे बड़ा अच्छा लगा जब मैं यहाँ आ पाया, क्योंकि मेरे आने की संभावना थोड़ी कम थी, इसलिए कि आज मेरा कोर्ट डे है, लाइन कोर्स चल रहे हैं, फिर भी मैं आ गया। मैं कुछ पढ़ के नहीं आया हूँ पढ़ाने के लिए, तो सारे विद्वान टीचर्स बैठे हुए हैं। मैं कुछ एक्सपीरियंस शेयर करूंगा कि जो आप मूट कोर्ट्स के बारे में कुछ आज जानना चाह रहे हैं, उसमें ये मूट कोर्ट एक्चुअल कोर्ट का एक रिहर्सल स्टेज। आप रिहर्स करते हैं, आप प्रैक्टिस करते हैं कि ओरिजिनल कोर्ट में जब जाएंगे तो हम कैसे काम करें। ओरिजिनल कोर्ट में जाने के पहले क्या लोग करते हैं? केस बनाते हैं। केस कैसे बनाते हैं? या तो कोई क्लाइंट आए या जैसे भी हो केस आपके पास है, केस में आप रिसर्च करते हैं, पढ़ते हैं कि केस है क्या, केस का फैक्ट्स क्या है। आप सबसे पहले केस के फैक्ट्स को पढ़िए, एक बार, दो बार, तीन बार, चार बार, जब तक आप पूरी तरह से समझ न जाए। आपको यह सोचना कि हमें समझना नहीं, हमें समझाना है। तो जब तक आप केस समझे नहीं तब तक आप पढ़ें। जब केस आप समझ जाए, उसका इशू क्या है, उसका इंग्रेडिएंट्स क्या है, उसका सॉल्यूशन क्या है, फिर आप उसके लॉ में जाए। वो लॉ के दायरे में कहाँ है, लॉ के परव्यू में कहाँ आता है, लॉ कौन सा, जैसे लॉ है हमारा कॉन्स्टिट्यूशन, लॉ है हमारा एक्ट्स, रूल्स, रेगुलेशंस, सर्कुलर्स। आप उसको उसमें ढालिए, उसमें जांचिए कि वो कहाँ बैठता है, और एक और लॉ होता है जो आर्टिकल 144 वन ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया बोलता है कि जो सुप्रीम कोर्ट का कोई भी जजमेंट्स है, जो लॉ है वो बाइंडिंग होता है ऑल द कोर्ट्स ऑफ इंडिया के अंदर जितने भी कोर्ट्स हैं वहां लागू होता है। तो देखिए कि जजमेंट्स में वो कहाँ आता है। जब आप पूरी तरह से रिसर्च कर लेते हैं फिर उसकी ड्राफ्टिंग ड्राफ्ट होती है, हर केस की अलग अलग होती है, हर तरीके जैसे कॉन्स्टिट्यूशनल मैटर्स है उसकी अलग होगी, एक्ट्स के अंदर जो आता है उसकी अलग होती है, किसी स्पेशल लॉ में है उसकी अलग होती है, सुप्रीम कोर्ट की अलग, हाई कोर्ट्स की अलग और सिविल कोर्ट्स की। उसमें आप देखिए कि कौन जुरिडिक्शन में आप जो जा रहे हैं कौन फोरम है, फोरम तलाशी, उसका जुरिडिक्शन देखिए कि किस जुरिडिक्शन में है, प्रोविजन ऑफ लॉ क्या है, पार्टी पोजीशन क्या है, किसको एड्रेस करना है, ये सारी चीजें देखते हुए प्रेयर में है। प्रेयर बड़ा इंपॉर्टेंट पार्ट होता है किसी भी ड्राफ्टिंग में। प्रेयर आपका ठीक हो गया तो आप आधी दूरी तय कर लीजिए, प्रेयर आपका सही होना चाहिए, फिर आप जाइए एग्रीमेंट्स में, आप क्या अपना आप सबमिशंस देते हैं और फिर वो लॉ उसमें क्या बोलता है, यही ड्राफ्टिंग। जब ड्राफ्टिंग आपका कंप्लीट हो गया तो आप आइए कि आप आर्ग्यू कैसे केस को करेंगे, आपका प्रेजेंटेशन कैसे कोर्ट में होगा। केस प्रेजेंट करने के पहले उसको 10 बार अभी शुरुआत में पढ़िए, पूरा फाइल पहला पन्ना से लेके आखिरी पन्ना, कोई चीज छूटना नहीं चाहिए, लाइन बाय लाइन पढ़िए, नोटिंग्स बनाइए। नोटिंग्स कहाँ बनती है, नोटिंग्स टॉप ऑफ द ब्रीफ है उस पर लिख डालिए, इस पेज में ये है, इस एनेक्सर में ये है, और वो भी आप 2-3 बार देख लीजिए, फिर आर्गुमेंट कीजिए। इस तरह से आपका आर्गुमेंट कंप्लीट होगा और आप एक अच्छा जजमेंट पा पाएंगे। धन्यवाद। और कुछ इसमें और भी कुछ है, वो ट्रैक आउट किया था हम ठीक से पढ़े भी नहीं, रिसर्च है आपका, ड्राफ्टिंग है और सबमिशन, प्रेजेंटेशन है। प्रेजेंटेशन में एक और चीज हम जोड़ना चाहते हैं कि आप जब किसी कोर्ट में जाते हैं तो प्राइमरी चीज है कि आप पोलाइट बने रहें, पोलाइटनेस के साथ जाएं, आपको चीजों की जानकारी हो, फेज वाइज है, हर कोर्ट का अपना अपना मूड होता है। अब जैसे हमारे जस्टिस तिवारी सर हैं, इनके कोर्ट में हम लोग बिना पढ़े लिखे भी चले जाते थे तो काम होता था, क्योंकि ये खुद से ही इतना प्रिपेयर होके आते थे कि आधा अधूरा भी आर्गुमेंट हो गया तो ये पूरा चीज लिखा देते और हमेशा एक अच्छा जजमेंट होता है। हर कोर्ट ऐसा नहीं होता, कुछ कोर्ट्स में आपको ज्यादा पढ़ के जाना पड़ेगा, कोर्ट का मूड देखना पड़ेगा, आपको अपनी क्रेडिबिलिटी बनानी पड़ेगी, आपकी हर बात को जज सच माने, इसकी तैयारी आपको पूरी तरह से रखनी चाहिए। ऐसा एक इमेज बनाइए कि आपको जज हमेशा समझे कि ये जो बोल रहा है वो सच बोल रहा है, और ये सब संभव है। इमेज आपका तभी बनता है जब आप कोर्ट में झूठ नहीं बोलते, गलत सबमिशंस नहीं करते, मिसलीड नहीं करते, जो फैक्ट्स है उतना ही बोलते हैं। 2-3 चीजों का ध्यान रखना चाहिए कि आपको क्या बोलना है, कहाँ बोलना है और कितना बोलना है। ये नहीं कि हर जगह जो लिखा हुआ है सारा चीज बोलते जाना है, ऐसा नहीं। कहाँ बोलना है, क्या बोलना है और कितना बोलना है, ये चीजें प्रैक्टिस से आएंगी। समझते हैं कि आने वाला समय आप लोगों के लिए बहुत सुनहरा है। हम देखते रहते हैं, ऑनलाइन क्लासेस चलते हैं, हमारे बच्चे बड़े मेहनत कर रहे हैं और आने वाले समय में आप लोग बहुत अच्छा करेंगे, हमारी ये शुभकामनाएं। धन्यवाद।
Thank you so much, sir. It was indeed an enriching and knowledgeable session. Moving forward, I am profusely elated to take an opportunity to introduce our guest of honor, Honorable Mr. Justice N.N. Tiwari, sir. Sir graduated with economics honors from GLA College, Daltonganj, and got master's degree in economics from Ranchi University and did law from CN Chotanagpur Law College, Ranchi. Sir practiced at Patna High Court, thereafter at Jharkhand High Court, Ranchi. Jharkhand High Court, and has a specialization in constitutional and civil matters. Sir was standing Council for Food Corporation of India and has appeared for several public sector companies, national banks, corporate houses, and educational institutions. Elevated as judge of Jharkhand High Court, he has delivered a number of landmark and path-breaking judgments on all the branches of law. Also, so has been appointed as chairperson, Jharkhand State Electricity Regulatory Commission, Ranchi. The government of Jharkhand has appointed him as chairman of Core Committee Ranchi and convener of the committee constituted for selection of vice chancellor for establishment of National University of Study in Research and Law. He has been the chairman of High Court Legal Service Committee, search committee constituted for the purpose of selection of pro vice chancellors of Ranchi University and Kolhani University. Executive Committee of Jharkhand Judicial Academy, Committee relating to Juvenile, Committee to Crime Against Women, Appointment, Promotion, Selection, ACP, and Absorption Committee, and several other administrative committees. So was the member of Standing Committee of Jharkhand High Court, Steering Committee of the E-Committee of Honorable Supreme Court of India, Finance Committee, Building Committee, and several other administrative committees. His judgments are reported in law journals of national and state level. He has been a keynote speaker in the number of state-level conferences, workshops relating to gender justice, judicial ethics, speedy disposal of cases, juvenile justice, plea bargaining, court management, case management, alternate dispute resolution mechanism, and etc. So it's an honor to have you among us here today. Please welcome him with a huge round of applause.
Vice Chancellor of this university, Sri Jha Sahab, Registrar of the University, Mr. Tripathi ji, Director, and it is a knowledge for me today that he is also actor. The most learned counsel, Mr. Bhavesh Kumar ji, the Kasturi Madam, I forgot, the faculties and the students. The special mention my secretary. I was given to understand that it is a blessing session and I have to just bless you. The day before yesterday, I was given a program in which I was made to speak on a subject, research and presentation skill for budding lawyers. Now, so far research is concerned, Mr. Bhavesh Kumar is right that the students over here are more expert in research than me. Everything they have researched. Nothing is to be said on research. And the other is presentation skill for budding lawyers. So how many students over here are planning to become lawyer? Raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9. Only 9? 9, 10 students. Other are interested in become the judge. How many of them are you? 1, 2, 3, 4, 5, 6. Equal number. And the rest others? Corporate. Madam Kasturi, your students, most of them are now interested in going to join corporate houses because there they will get handsome amount. So this is the irony. This is the irony. I know number of talented students of law who have done exceptionally well. They joined corporate houses and wasted their talents. Because at the threshold, at the time of joining, you see the yes, 80 lakhs, 50 lakhs. So you are influenced by that amount. And without knowing what is the pain behind the curtain, the students join such corporate houses and spoil their talent. If actually you want to become an asset for the society and soar in the sky, soar high in the sky, then the only field is advocacy. Advocate, my dear students, there is no limit of earning, no limit of name, no limit of fame. Except this, everywhere there is limit. But if you want to actually become of the exceptional value in the society and for your country, I will advise you to join the profession as a lawyer. I have seen it. I have seen it. I have felt it. I was the lawyer. I became the judge. I also held other prestigious position. But my conclusion today at the end is that there is no match of the career. There is no career at par with the career of lawyer, or if you become advocate, you can create your own field, your own fame, your own earning. That is limitless. So if you are actually, whoever nowadays opt for law, they are talented people. And I advise you to reconsider your priorities and to join this profession. I will give some tips to you. We have heard for 2 days so many learned speakers, and nothing is to be said so far. Theory, knowledge, and the other requirements for success in the field of law. I am not going to delve into such matters which have already been told to you. I will say some story to you. The one story which influenced most in my childhood, my father told a story, small story. Have you heard the name of Alexander the Great? Alexander, yes. So, in his darbar, there was a very loyal and serviceable employee. When he became old, and when it was a time to retire, Alexander called him and asked, "You have done a very appreciable service to the kingdom, and you are very loyal to me. I want to do something for you. What can I do for you?" He was very clever. He said, "My lord, you have given me everything I got my house. I I was very conveniently placed in society. I have a son. So what can I ask? I have everything now. My only wish is that I want to be attached with this kingdom and especially to your laws. And the only hope is my son, my only son, but he's only 16 years of age. I don't think he's fit for anything. Alexander was thinking to give him something. I told him, "Oh, all right, you send your son one day. So I will just converse with him and see what can be done for him." The person asked 1 week time. He was taken by surprise. He was not prepared for that. They thought that I would prepare my boy for the interview. After all, he's coming to meet Alexander the Great, the emperor of the day. It was not a mean thing to just appear before the emperor those days. So yes, all right. Send your son after a week. After a week, in between, he taught him. Oh, you have to go to the royal house. When you come with this position, meeting the royal people is a very rare opportunity. So he taught him how to go, how to behave, and what reply should be given to what question and query. His son attentively heard for a week. His father told him, when you will enter before that, you just go down and say, "Yes, my Lord." Heard everything. On the day, he went to the royal palace. One person was waiting for him. He was received. He was brought before the emperor. Before he could utter any word, he could not understand who is emperor. So the emperor went him and held his both hands, not uttering a word, and said, "Bolo, kya bolna?" I was taken by surprise. My father has not, not said that this will be the situation, but he was very intelligent. Back came the reply, "My Lord, in Hindu society, when a man holds hand of a woman, he takes charge of everything for his life. The emperor is holding my two hands, both the hands. What I have to say? I have to say nothing." This was his interview. This was the reply. And he was given a very prestigious position. He was made head of the person. His father was a servant of this household affairs, and he was appointed in the age of 16 years as the head of the home affairs for the entire This was entire kingdom, for the entire kingdom. So what type of tips you require? I will say, oh, do this, that, do that. And the another one. One young graduate from Harvard University, very talented. In Moot court, he won several gold medals. And he was the headline boy. Every law students of those days and the others who were concerned with law were acquainted with him, his performance. Gold photos were printed in all the leading newspapers. So he joined a senior barrister in England. And everybody was waiting, all the barristers, yes, he should come to me and join. So he joined one barrister. And a case of appeal was given to him for argument, the very first day. Then he prepared the case. And the way Mr. Bhavesh Kumar suggested you, read this you should be acquainted with your facts and read the law. So he was very intelligent. He was gold medalist in law, so he has a very good eloquence. So he prepared the case, and the day on which the case was to taken on board, he appeared. When he appeared and he started arguing, he was overconfident, full of confidence. I know everything. I have read all the facts. I have read all the relevant decisions. I know all the relevant laws. So what more is required? I was very confident. But when he started his argument, when the case was called, he started his argument. My lord, this is appeal against the, yes, Mr. Service. The judge asked, service? Twice he said, service? Then the clerk, who was standing behind the clerk, he just whispered in his ear, proceed, sufficient. Well, yes, proceed. But he could not know what is this, what is service sufficient? So this is the difference between the theory and the practice. As Mr. Bhavesh Kumar rightly said, there is difference. Service means the appeal is to be taken only, the notice is served on the other side. The case was being taken up for the first time, and the judge was to be assured that service has been, the service is sufficient, notice was sent to the other side. But he was not acquainted with this, the court craftsmanship and the practice of the court. So he was prepared, law, facts, everything. But he was so confident that when he did not go to his senior and ask him, sir, how I should proceed. So, and he won the case, he was fully prepared. But when he came out, he asked the clerk, what do you mean by sufficient? What is sufficient? He told, service, Mr. The case is only to be taken when the service on the other side is sufficient. So another interview, this is another story. Everything you have learned now, no theory practice. I'm not going to say anything on that. There was a very high position in a corporate house. The students joined these coaching classes for interview. They learned all the techniques, how to behave. Just when you go there, just ask, may I come in, sir? then you have to address the chairman in this way, in that way. Now, on the day of the interview, the person who was selected, he faced a curious situation. When he was called outside the gate, the chairman of the committee and the corporate house itself was standing at the gate. At the gate, he introduced, I am Mr. Das. Now the chairman said, I am the chairman of the board, and I am chairman of this corporate house. He was not prepared. Then he just, out of his intelligence, replied, sir, so what I learned, I see now in practice, what? That all the great men are humblest. The interview was over and he was selected. All the great men are humblest. He was selected, others were rejected. Meaning thereby, my students, you have to apply yourself. You have to, there is no state bracket formula for teaching you mooting, for preparing yourself. But of course, certain things, which Mr. Bhavesh Kumar also told you, and you heard so many speakers. Now I am appreciative of the person who has selected this topic, presentation skill for budding lawyers, very important. The most important part, not only mooting, not in success in the profession, but in the success of your life. The art of presentation, the skill of presentation. Now, do you know what is the difference between the hotel, which is 2-star, 3-star, 5-star? What is the difference? Anybody can say? The only difference is way of presentation. The same tea, even inferior tea. Inferior tea. You just go and in the all 5-star hotel, almost all 5-star, I have okay to go. So you can get better tea in a stall beside the road. But there only, this is the art of presentation. They are charging 1,300 rupees for a cup of tea. You will get better tea on 5 rupees. For 5 rupees you will get on the roadside. 1,300, 1,300 per cup. So this is the difference, which the way of presentation makes in your life. Everywhere, in every sphere of your life, it is the presentation which is important. If you learn this skill, not only that you will succeed in your professional career, you will succeed in your life, the way of presentation. The presentation so far the lawyers are concerned, what is the way of presentation? Presentation before the court. The first and foremost, that is a very important role is presentation of yourself before the court. I was the judge. I was a judge. And we created impression only after first look of for some of the council. The first look itself, that yes, he's very smart, he's very knowledgeable, and he's very fair. So first presentation of yourself. What is your presentation? First, you should be very neatly dressed, nicely combed, and you should present yourself as you are the hero of the day. I don't just misunderstand me. I don't want to say heroine. Hero. Yes, hero of the day. What is hero? Hero means that he is overconfident with all the human equality. This is hero. Not that Majnun type of hero you just see in the street. Multicolor of hairs and my barber usually come from hair cutting. He was telling me the day before. Yes, sir. Nowadays we are getting 4,000 for one haircut. I asked 4,000 for one haircut. Yes, yes. How? There are so many now styles, and for a style, making that style, so one Eastman color style, so turning the black hair into white, maroon, blue, so many colors. So when we make 7 colors in one head, so we get 4,000, 4,000, 4,000. Not that hero. Here, the hero should be the hero. He is the real hero. Real hero means you must have a confident personality with all the good qualities, with all the human qualities. Now, time is very short, so I'm not going to that, what is human quality, but if you are well dressed means the well required dressed, well dressed for the court, not for the street. It attracts the attention of the judge. Your presentation, nicely dressed, well combed, nicely cut hair, which is now very rare. So your presentation yourself, first, this is the first impression you are creating before the judge. Your look. So always you have to devote some time to stand before the mirror and to judge yourself that yes, now today I'm looking nice and I'm very confident, I'm well dressed. Appear before the judge thereafter. So your presentation in the court room, even for the mooting, your presentation before the judge, very important, your presentation. The other presentation which is required most is presentation of the documents before the court. Presentation of the documents that also exhibit the personality or the makers of the draft. The draft should be always prepared only after full preparation. The topic which I have been given also has one leg, importance of research, which I skipped because I told you earlier that you are very expert in research. What is research? The research is, this is the preparation and the difference between the preparation and research. Preparation is that good preparation. Suppose you have to prepare a dish, halwa, moong ka halwa. Then if you are applying the ingredients in right proportion, your recipe is well prepared. But what is research? Research is that you are giving also toppings of several, say, dry fruits, other fruits, multicolor appearance. This is research. One is preparation, another is research. So presentation of your draft before the court, that should be all made after a research. When you are given a case, if you have to draft anything, a plaint, a petition, an appeal, or anything, reply, what I used to apply is, whenever I was given a case in my early age, I'm just sharing my experience. It may not work well with others, but this is my experience. So whenever a case is given to me, I used to call the person twice, thrice, and try to know what is the material, what are the documents, and what are the quality of evidences with the other side. All the great wars are won by strategy, not only by army. A strategy. So for making this strategy, you have to know the strength of the other side. If you have to win, then you must know the strength, the armory. What is the latest arm with him, other side? What are the materials against you? And what are the case laws against you? If you are able to know what are the decisions against you, what are the materials against you, which you are going to face, you are well prepared. And this is the use of the research. If you are preparing your case, you are well prepared, all right. But this is not research. Research is that every bit of thing you have to foresee from the date of presentation of the case till the end. If the case is being presented in the first court, you have to foresee what will happen in the trial, what will happen in the appeal court, what may happen in the Supreme Court. So if you are prepared in this way, I think, and this is my experience, you are going to hardly lose any case. Now people say, the lawyers say, oh, I was well prepared, but I lost the case. You are well prepared with your case. You are not prepared to face the situation which is coming to you and which may come against your case. You are not prepared. So this is my experience of presenting the thing, that whenever I was given a case, I devoted so much of time in knowing the other side, his points, his documents, the quality of evidence to be produced by him. And in this way, in so many cases, the other side were disarmed. Oh, you already said all these decisions. In several cases, you will find that the other side is not even ready. He does not know all the decisions in his favor. But when you point out, these are the decisions, my lord, which may be cited against me, the other side is disarmed. But there is no reply now, because you have already cited all the decisions of the other side. What points may be argued by the already argued? The judge will say, Mister, this has already been argued. Any new point? Other side maybe in some cases may be dumb, without any reply. This is called research. So this is the way of presentation of your case. Now the very important part is the argument, oral argument. Now in several cases I came across in long practice, legal practice as an advocate and also as a judge, that the lawyer tend to conceal the facts which are against them. They tend to conceal law which are against them. They tend to conceal the points which are against them. Now they think that the judge who is sitting there is very innocent. He does not know. I will go through. He knows everything. And you may be able to create a great impression about you if you think, my lord, these are the weaknesses of my case. These are the points against me. These are documents against me. You are going to make a big impression, a very good impression before the judge. And in so many cases in future, the judges will rely upon you to that extent. They will no, Mister. Yes, one, the other side, sir. My lord, see this page. Yes. All right, he has already said. Now, any other point you have? So this builds the confidence. This builds the confidence of a judge in you. Don't conceal anything. Don't conceal anything, because concealing means you are going to lose not only this case, other cases also. Many good cases are lost sometime because the judge's impression. Record हो रहा है क्या? नहीं हो रहा. If a judge has a bad impression against a lawyer, so many cases he loses, even he has a good case. So this is the first and the foremost quality you have to imbibe. Is to that you have to create such a confidence in judge that he is doubly sure that you are not going to cheat him, you are not going to mislead him. Great thing you have to learn. And this is very rare quality. The percentage I must say 0.1%. 0.1%. 0.1% means कितना हुआ? Against कितना हुआ इसका against? 99.99. Persons, they conceal the facts. They never disclose what is the weakness. They never disclose what are the materials against him. They never disclose what are the decisions which are against them. But that one point will make a distinction, and a distinguished lawyer, and this is very important for a lawyer to know, that don't conceal anything. And cite the decisions which are against you. Question comes, if I cite decisions against me, how I am going to win? This is called a skill. You are going to win. We are going. The decisions are made. The judgments are passed on the facts of each case. No case is equally same. No case is equally same with others. Each case has different facts. And the law or the decisions are applicable only when the facts are same. The fact situation is the same. When the facts are not same, the decision is not applicable. And in each case, the facts are different. Even if the decision is supposing landlord tenant, that a tenant who is a defaulter in payment of rent for 3 months continuously is liable to be evicted. The general law. General law. Your client is defaulter for more than 3 months. And if you are going to cite the decisions on this point which are against you, you will think, oh, I am going to lose this. My client is defaulter for 3 months. And this comes the role of skill of a lawyer. Now see, what were the circumstances under which your client defaulted in payment of more than 3 months? He had gone to Russia. There was a war between Ukraine and Russia. He came back after 6 months. There was default of 6 months. What? Was it intentional? Was it intentional? No. Under the circumstances which were beyond his control. So you have to explain the circumstances under which payment could not be made, the rent could not be paid. This distinguishes the case law that the defaulter of 3 months rent is liable to be evicted. In your case, he will not be evicted because he is not a defaulter intentionally, but under the circumstance which was not in his control. This can be distinguished only by going and delving deep into the facts of both the case in which you are, the case which you are citing, and the case in which that judgment was passed. So, the law is law. I can spell. Yes, my lord, I know that a person who has defaulted payment for 3 months is liable to be evicted. Judge will be happy. Yes, mister, your client has defaulted for 6 months and I got the answer. Then thereafter you have just to do, my lord, but some more submissions I have to make. What is that? You accept that your client has defaulted for 6 months? Yes, yes, my lord, not denied. Then you have cited the case that defaulter of 3 months will be evicted. What more you want to say? My lord, kindly see the circumstance. I have stated in these paragraphs, and the judgment which has been rendered, it has been rendered with the facts. Kindly see the paragraph 4 and 5. He has intentionally defaulted. My client has not intentionally defaulted because you are stranded in Ukraine due to war. All right, yes. Mister, he has not defaulted intentionally. The judge will be in your favor. Judge will appreciate your fairness, and the judgment will be surely in your favor. So don't feel shy in citing the decisions which are against you, but this should be always go and research the differences in the facts, and you place this fact before the judge. And in most of the cases, you are going to win. Not you are going to win only the case. You are going to win the confidence of the court, which will help you in the future. This is the way of presentation of argument. Now, more you learn, more you practice, more you can learn the skill of presenting the case. Now, can you say, any one of you, what is the most important, that what kind of knowledge which has the most important role to play for a good argument? What should know? What should one know? Anybody? No. Right, there are three components. Three components which make a lawyer perfect lawyer. That he should know act. Act means law. He should know facts. And all, he should know tax. Which is more important, anybody? Act, fact, or tact? Yes, ma'am? Tact, act. Last one is foremost, yes. Very intelligent lady. Last one. This is tact. Everybody may say, oh, I know law. I know all my facts, master of facts. Say, all the theories. All the theory will tell you, will be taught here in courts. All the learned speakers will do. You should be master of facts. You should know the law. I say you should know the text first. Of course, act and fact also. But you should know the text. Everybody knows acts. Everybody learning here, everybody reading law. All are acquainted with law. Everybody reads facts. Whenever a case is given, he goes through the file, the brief, and he knows the facts. The distinction between a successful lawyer and unsuccessful lawyer is that difference of knowledge, the difference in knowledge of text. What is this text? Most of the lawyers and the young people say, "Arey yaar, बुद्धू बना लो, यही तो टैक्ट है." इसी तरह से गोल गोल करके घुमा लेना है जज को। क्या जज घूम जाएगा आपके गोल घुमाने से? नहीं, बट आप समझते हो कि घूम जाएगा। हम इस तरह से करेंगे, कुछ इधर कुछ उधर, जज घूम जाएगा, नहीं घूमता। What is the tact? Tact, here vice chancellor is here. I must say that ये यूनिवर्सिटी का एक सब्जेक्ट, फुल फ्लेजेड सब्जेक्ट होना चाहिए टैक्ट का। अगर एमिटी यूनिवर्सिटी अगर ये इंट्रोड्यूस करे टैक्ट का डिप्लोमा इन टैक्स, लीगल टैक्स, नो एनी टैक्स, everywhere. If you have to succeed in any sphere of life, if you are tactful, you are successful. Maybe you may be very learned, PhD, delete everything. If you don't act, I know so many of doctors here, so many of lawyers, so many qualifications, London, Edinburgh, Paris. So doctors here. There was one, I'm not going to take name here. One doctor had 4 lines degree. 1, 2, 3, 4, 5. इतने में आता था. कितना होता था डॉक्टरी में, जो होता है MRCP और उसमें जितना चाइल्ड स्पेशलिस्ट या चाइल्ड के डॉक्टर, सारा डिग्री था. अब डॉक्टर्स reputation was that he had to imply some doubts to bring patient. वो उनके डाउट्स जो होते थे वो होते थे ऑटो वाले, रिक्शा वाले. जब चढ़ते कोई पेशेंट स्टेशन पर, अरे कहाँ जाना है? डॉक्टर साहब के पास. अरे एक ही डॉक्टर है, 4 लाइन की डिग्री है, देखोगे. उनको पेशेंट लाना पड़ता था. And I also know so many doctors only with qualification MBBS simple. MBBS simple. लाइन लगी हुई रहती. आप जाएंगे तो लाइन कब का मिलेगा? सितंबर का. कुछ नहीं. ये क्या है? Not only me, a very great doctor of this place, and he agreed. Yes, yes, sir. Rightly, sir. Rightly, sir. Doing this MBBS is nothing. It is a certificate, but it is not a certificate for becoming a good doctor and becoming a successful doctor. He was also of the view कि MBBS में भी एक पढ़ाई होनी चाहिए, क्योंकि टैक्स, हाउ टू डील विद द पेशेंट. So if you have tact to deal with your client, if you have tact to deal with the court, if you have tact to deal with your colleague, if you have tact to deal with the society, you will be a successful lawyer. You will be a successful man. Everywhere you will win. Now, what is this tact? Cannot be defined in 1, 2, 3 lines. But main thing is that you should present yourself before the others. One should present himself before the others in the way that he should receive you very harmoniously. Very harmoniously. You should make yourself receptive. आप कैसे रिसेप्टिव बनाएंगे? एक हमारे यहाँ एक मैडम है, वो जब आती थी तो थोड़ा उदास मुंह करके आती थी, और देखते लगता था अरे क्या क्या बात है. हमने उनको कहा मैडम जरा मुस्कुराते हुए आइए, मुस्कुराते हुए, मेक योरसेल्फ रिसेप्टिव. आते अच्छा अच्छा ठीक है, always have a smiling face. Smiling face बना. तो स्माइल का भी बहुत तरीका है. All are smiling here. स्माइल का भी बहुत तरीका है. किसी का होता है $1,000,000 स्माइल, उसमें भी रेट है, जैसे 5 स्टार 2 स्टार. स्माइल विथ कॉन्फिडेंस, रेडियंस. रेडियंस से स्माइल करो, कॉन्फिडेंस से स्माइल करो. वो कैसे आएगा? नाम आपने सुना होगा, नॉलेज इज पावर. पावरफुल स्माइल होना चाहिए आपको. उसके लिए क्या करना होगा? You have to acquire vast knowledge. Vast knowledge. पढ़ो, सारे सब्जेक्ट्स को पढ़ो. If you want to become a good lawyer, You are not supposed to only read law. You are very happy. हमें तो एविडेंस में 94 नंबर आ गया, क्या होगा उसका? Gold medalist. I've seen failure in professional life. And the person who got 45%, 50%, were passing marks, they have become very successful on it. इसीलिए मैम टैक्ट जो है बहुत very important, very important. Although the other two wing, that is act and fact, that is not less important, but the tact is number one. Tact. आप अपने घर में, आप बाहर में, इंस्टीट्यूशन में, अपनी सोसाइटी में, अगर आप टैक्ट जानते हो, टैक्ट में रिसेप्टिव होना, दूसरे आपको चाहें, जब आप आए तो खुश हो जाएं, कैसे खुश होंगे? You have to inculcate good qualities, good human qualities. What is good human qualities? Don't misbehave with any, even with your adversary. Treat him. आप क्या अपोजिट साइड से आ रहा है, हाथ मिलाने में क्या लगता है? हेलो मिस्टर झा, हाउ आर यू? इसमें क्या लगता है? तो अपीयर हो रहे हैं उस साइड से, ना बोलना नहीं, इधर देखना ही नहीं, उधर अदर साइड है। ये इन प्रोफेशन आपके साथ साहब हैं, he also acted in a case as a judge. क्या है उसपे? जज थे, अब डायरेक्टर हैं। Now what is bad? आप एक करो तो भीतर में ना भी रिस्पेक्ट हो तो रिस्पेक्ट दूसरे टू योर कलीग्स। आप यहाँ पर जो आप लोग होंगे, इसमें कोई जो बहुत चहेते होंगे सब साथियों, अरे यार क्यों रुआसा मुंह क्यों बनाए, क्या बात है बताओ, हम है ना, कुछ नहीं मांगता, कुछ कोई नहीं मांगता आपसे, इतना बोल दो हम है ना, क्या बात है बताओ, अच्छा दिक्कत है तो चलो हम चलते हैं। ये आपका इंप्रेशन बनाएगा सोसाइटी में। डेवलप ह्यूमन क्वालिटी विद इन यू, फॉल्स नहीं, ट्रू। ट्राई टू हेल्प अदर्स। आज से संकल्प करो कि हम किसी न किसी रूप में, in any manner, to any extent, I will help others. This will make you happy in your life. बस one quality you develop. सारे जिंदगी लोग गुजार देते हैं, लेकिन दूसरे की मदद नहीं करते। अगर हम करेंगे तो बढ़ जाएगा आगे, हम पीछे रह जाएंगे। जितने भी ग्रेट मैन हैं, माय डियर स्टूडेंट्स, सारे लोगों की ये स्टोरी देखो, उनकी लाइफ स्केच देखो, दूसरे के लिए जिए तब ग्रेट बने। दूसरों के लिए किया उन्होंने। यू आर नॉट एन एनिमल, मैन इज ए सोशल एनिमल। यही डिफरेंस बिटवीन अदर एनिमल एंड मैन, ह्यूमन। तो आप सोशल एनिमल हो, एनिमल नहीं हो। एनिमल क्या करता है? दूसरे को देखा मारना शुरू, नहीं, दो कुत्ते अगर मिल जाए, देखा, कोई भी ले लो, जहां दूसरा को देखा बस लड़ना शुरू। यू आर ए सोशल एनिमल। कह दिया कहने वाला, मैन इज ए सोशल ह्यूमन बीइंग। क्या है ह्यूमन बीइंग? आप हैं ह्यूमन बीइंग, तो आपका क्या है? ह्यूमैनिटी। क्या ह्यूमैनिटी क्या है? ह्यूमैनिटी यही है टू हेल्प अदर्स, परोपकार करो। आप ये करोगे तो आपकी पर्सनालिटी लाइक एनीथिंग डेवलप करेगी। आज से देखना, अभी जाते समय लौटो यहाँ से, कोई बूढ़ा आदमी हो, शक नहीं रहा उसके, कुछ उठा रहा है तो हाथ से बस उठा दो, ए बाबा ठीक है हम उठा देते। आजकल गए चलो देखो यार, इधर देखो। ये आज हमारे सोसाइटी में जो पतन हो रहा है, अपने माँ बाप को, अपने समाज को इग्नोर कर रहे हैं। हमारे ये जनरेशन, ये पतन हो रहा है, जो डाउनफॉल हो रहा है। आप जितने लोग हैं सारे स्ट्रेस में इसलिए रह रहे हैं, केवल एक ही क्वालिटी आप में नहीं है। सुबह से उठ करके दूसरे को तकलीफ पहुंचाना आपकी क्वालिटी है। पहला मदर, नहीं उठेंगे अभी, रुको अभी, मोबाइल रखना है, रुक जाओ। ये हमारे बहुत से SMS आए हैं, क्या क्या आजकल कौन ग्राम है, इंस्टाग्राम, अब ये देखो ट्विटर, तो ये सारे चीज हैं। ठीक है, देखो you have to also march with the latest implements and the development, लेकिन ओल्ड वैल्यूज जो है वैसे ओल्ड है, ओल्ड वैल्यूज नहीं है माय डियर स्टूडेंट्स। ये ह्यूमैनिटेरियन वैल्यू कितने हैं ये आप भूल रहे हो। तो जिसको भी अपने आप को इम्प्रेसिव करना हो, डिस्टिंग्विश करना हो, स्टार्ट थिंकिंग इन दिस वे कि आप हर जगह अपनी यूटिलिटी प्रूव करो, जहां भी जाओ अमंगस्ट योर कलीग्स, और ऐसा बनो कि दूसरे भी जो हैं, जो आपके अपोनेंट्स हैं, वो भी आपकी कदर करें। तब समझना हम टैक्टफुल हो गए। दिस इज योर टैक्ट, यही आपका टेस्ट है टैक्ट का। आपको दूसरा कैसे लेता है, बी ए जज, बी योर पेरेंट, बी द सोसाइटी, बी योर फैकल्टी, बी योर कलीग्स, आपको कैसे रिसीव करते हैं। अगर आप अपने को ये बना लिया, सक्सेसफुल हो गए, कल्याण हो गया आपके लाइफ का। आप जो चाहो कर लो। यहाँ भी यही एप्लीकेबल होता है, टैक्स in every way of life, and particularly if you want to succeed in the legal career, legal professional के रूप में, या आप बनना चाहते हो, if you want to join in any corporate house, anywhere, learn the tact। कुछ लर्न करना नहीं। टैक्ट ऐसा है जिसकी कोई किताब नहीं, कोई किताब नहीं, बस यही ह्यूमन बन जाओ, डेवलप ह्यूमन क्वालिटी। ह्यूमैनिटी का पढ़ लो चैप्टर, उसमें यही कहा कि आप अपने आप को ऐसा कैरेक्टर बनाओ जो कि हार्मोनियस इफेक्ट रखे आपका। जहां भी जाएं, आप जाएं तो लोग खुश हो जाए। ऐसा नहीं कि गए तो दुखी हो गए, यार कहाँ से आ गए। कुछ लोग यहाँ पर मुस्कुरा रहे हैं, उनके साथ ऐसी घटना होती है। आए थे जब, अरे क्या फालतू आ गए, जब माथा चाटेगा। ऐसा मत बनो। आओ, जो गए यहाँ से खुश हो जाए। आज आप जाइए, पहला काम अपने घरों में आप करिएगा। जाते देखिएगा कि कहीं पर कुछ सामान रखा है, उसको ठीक से रखो। हेल्प योर मॉम, हेल्प योर डैड, हेल्प दी सोसाइटी। किसी कहीं भी कुछ भी करो, then you will become great man। आप ग्रेट क्यों नहीं बनते हो? क्योंकि आप ह्यूमैनिटेरियन जो कंसिडरेशंस हैं उससे बहुत अलग हो गए हो। कोई परवाह नहीं आपको, किसी के लिए परवाह नहीं है। तो ये टैक्ट कुछ नहीं है। झूठ बोलना, नो 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 नो, रॉन्ग सबमिशंस, दूसरों को घुमा देना। अरे करके ले लिया ना, तो उन्हें पापा को भी घुमा देते हैं। आसान है। और एक लड़की ने कहा हमको, सर हम तो थोड़ा रो देते हैं, बस बाबू जी देते हैं, ऐसे मिलता नहीं है, लेकिन थोड़ा रोए, क्या हुआ बेटा? दिस इज नॉट टैक्ट। क्योंकि अगर मालूम हुआ कि बेटे को पेट में दर्द नहीं था, दूसरे रोए से कुछ नहीं मिलने वाला है। ये टैक्ट से नहीं। इसलिए make yourself respectable everywhere, and this is also applicable in this profession. किसी भी वे में आप रहो, अपने को दूसरा आपको कैसे चाहता है, कैसे चाहेगा. Try to inconvenience the others to the minimum extent. इसका क्या मतलब? वो आप जैसे बैठे हो, मान लो शेयर कर रहे हो, कोई ऑटो कर रहे हो, उसमें आपके साथ एक बैग है, एक आप हो, बैठ गए, बैग रखा, दूसरा बैठा. भाई साहब थोड़ा सा दिखते नहीं है क्या? बैग है मेरा यार, थोड़ा साइड होकर बैठो. ये है. तो आप हर जगह अपने को रिसेप्टिव बनाओ, दूसरे को आइए ऐसा भाजिए. वे वृद्धा को देख लिया, उठ गए, माता जी आप आकर बैठ जाइए, हमको क्या खड़े. बट इट इज वेरी पेनफुल. ये देखना कि कोई साइड में कोई अगर गिर गया, दूसरा केयर नहीं करता है. ये सोसाइटी की हालत. बगल में कोई भूखा मर गया, दूसरा सोसाइटी का बगल का आदमी उसको केयर नहीं करता. आप कैसे ग्रेट बनोगे? इसी तरह से जब लॉ में अगर आप सफल होना चाहते हो तो ये टैक्ट सीख लो, ये रिसेप्टिव बनो. लॉ और फैक्ट तब काम करेगा. whoever comes to you, एक बार में आया वो आप ही का हो गया. अरे यार ऐसा एक बार बात करो आप उसी का हो जाता है. यही तो टैक्ट है. जो क्लाइंट आया एक बार में क्या करना है, क्या करना है? यस तुम बोलो. थोड़ा क्लाइंट है आपके पास, थोड़ा दमदार वाला, तो क्या करना है? यस यस यस. नॉट ऑडिबल. क्या करना है? जैसे अभी सुन के बोल रहे हैं आप, नहीं तो ये कि जितना सबको एक बार में ही कैसे करेंगे. इसीलिए हमने कहा कि कोई आया, देखा कि तो बड़ा आदमी है, कंपनी का मालिक है, कुछ है, आपके पास आया, मैडम है मेरा केस है, तो आप क्या करें?
तो उनकी बात सुनेंगे.
हाँ, इसके बाद
फिर उनको इनसे अच्छे से बात करके उनकी जो प्रॉब्लम है उसको सॉल्व करने की कोशिश करेंगे.
ये तो बहुत अच्छी लड़की. ठीक है बैठिए. अच्छा आज ऐसा नहीं है बाबू, आज ऐसा नहीं होता है. आज ये है कि हम कैसे, ये आदमी बड़ा है, हमको कैसे पहले कितना आएगा असेस किया, पहले देखा आदमी है, बड़ा आदमी है, तो चाय पिलाओ इसको पहले, पूरा देने वाला है. कोई आ गया बोला वो तो वो आदमी है, उसका कुछ नहीं है, लैंड वेंड, बोला उधर ही रखो. ऐसे आप एक्सपेक्ट करते हो बड़े बन सकते हो सोसाइटी में? जो मिशन से तुम भेजे गए हो एज ए ह्यूमन बीइंग, उससे बड़ी दूर चले जा रहे हो. तो आप जहां भी जाओ, प्रोफेशन में रहो, क्लास में रहो, घर में रहो, ऐसा करो कि आपके जाने के बाद वो माहौल ही वहां पर हार्मोनियस हो जाए, खुशी का माहौल हो जाए. इसी को बोलते हैं टैक्ट. अब इसके लिए जिसको जो करना है, हमको स्ट्रेट जैकेट फॉर्मूला कुछ नहीं. इसके लिए क्या करना चाहिए आप बताइए? आप अपने को वेल रिसेप्टिव बनाने के लिए क्या कर सकते हैं? क्या करना चाहिए? व्हाट क्वालिटी शुड इम्बाइब?
So it should be more as you said.
No, I am not saying. I just want to hear you. What do you want to say?
Be more receptive.
Receptive, how?
So socially more, give positive vibes. Always try to listen first, and think that if I would have been in that position, how should
Well, only listening we do.
No,
Everybody who listens nowadays does nothing.
not only hearing.
What is your contribution to the society? What is your contribution to the colleague? What is your contribution to your family?
Helping as a person
Right.
in every possible way that I can do.
Right. That will make you great. बस टेक्स्ट का ही एक समझ लेना, एक लाइन का, और वन वर्ड आई एम टेलिंग यू, मेक योरसेल्फ हार्मोनियस एंड रिसेप्टिव. इससे बड़ा टेक्स्ट कुछ नहीं है जीवन में सफल होने के लिए. कैसे होंगे? जब ऑनेस्टली यू विल try to solve problem of others. Honestly, you will try to help others. I like law field. What you have to do? Anybody who is coming to you for justice, your first and foremost consideration should be that how you can bring justice to him. How you are bringing about the justice. आज कंसिडरेशन दूसरा है, मटेरियलिस्टिक कंसिडरेशन है. आप जहां भी जाओ उसी से जज होता है. तो ये तहत जब जानेंगे तो सोसाइटी में यू विल बी डिस्टिंग्विश्ड. ये ऐसा नहीं है. एवरीबडी विल कमिंग टू यू. ये लॉयर है, जेन्युइनली काम करता है, सोसाइटी को हेल्प करता है. एंड मनी, माय डियर फ्रेंड्स, ये मनी जो है ना, इसकी एक कहानी है. इसकी ये मनी ऐसा है कि आप अगर उसको पकड़ना चाहोगे तो भागते जाएगा. जैसे पकड़ना चाहोगे, पकड़ो मत उसको, देन मनी विल फॉलो यू. आज ये सीख लेना आपने. इफ यू वांट टू अर्न मनी, डोंट फॉलो मनी.
Or you will not be able to get money. समझ गए? आप सीखी जानते हैं, सीखी बटरफ्लाई. अब पकड़े हैं कभी? वेरी डिफिकल्ट, वेरी डिफिकल्ट. पकड़ते रहो जाते से भाग जाते. तो उसको पकड़ने का क्या तरीका है? तो बता सकता है? Become a fragrant flower बन जाए. क्या बेटा? तो सुगंध वाला फ्लावर बन गया. क्या होगा? अरे एक नहीं, क्यों है? अब उसको पकड़ने के पीछे चल रहे हैं. इस घर दौड़ के चले गए ऐसा सुगंध अपने आप में करो, ऐसा काम करो, मनी विल फॉलो ऑटोमेटिकली. ये जो है ना, ये मनी कुछ नहीं है. तो
मनी कुछ है.
तो नाउ
कितने रजिस्टर बने हुए हैं?
Oh, I'm very sorry that everybody here speaks from बैठे हुए हैं. अब पता है कि यंग पीपल जब मिलते हैं तो किस तरह तो पता नहीं चलता है. तो I'm just cutting short my address. That for developing the skill of presentation, most important part is developing the quality of food. Then comes the fact. क्या रिवर्स होता है? पहले हम तो लॉ सारे जानते. Then you, but Mr. फैक्ट पहले जानोगे. नहीं, लास्ट शुरू करते हैं. Fact, but develop this quality because this is rare quality and it is hardly taught. I will question Mr. Jha कि अगर हो सके तो इसका पढ़ाई कराएं. ये नहीं मिलता नहीं है, फैक्ट की पढ़ाई होती है. बाकी आप ऐसे पढ़ लो, so many faculty learned person are here. पढ़ा देंगे सारे लोग। कंट्रैक्ट का इन्होंने कहा बहुत अच्छा तरीका।
नहीं ना, मेरे को तो पढ़ाना पड़ता है।
तो ये पढ़ाई होती है, यह तो डेवलप और एक क्वालिटी हमने बना दिया। आप दूसरे को हेल्प करो, दूसरे को जहां तक कम हो इंकन्वीनियंस कम करो उसका। अब कोर्ट में जाओ, अगर लॉयर बनना है तो आप कोर्ट में जाओ, दूसरों को हेल्प करो, दूसरे जो लॉयर हैं उनका क्या करो, अच्छी बात बोल सकते हैं। एक को हमने कहा, बोला सर हमारे पास तो है नहीं, हम क्या क्या कर सकते हैं, अरे बात तो बोल सकते हो। अच्छा अच्छा, हमने कहा बात भी बोलने में अगर दिक्कत हो जाए, अच्छा पूछ तो सकते हो कि इसका भला हो सर। अब ये सोचो, इसका भला हो, हम क्या सोचते हैं, ऑनेस्टली बोलना, हम क्या सोचते हैं, हमारा भला हो। We lack tact. आप अगले का सोचिए, इसका भला, इतना ही सोचिए, ज्यादा कुछ नहीं सोचिए। इसके बाद you must have mastery of tact. जो केस होगा आपके पास, मास्टर बन जाओ। मास्टर के लिए रिसर्च करो। हमने कहा हम ये मॉडल अप्रेंटिस मेरा था कि हम पहले देखते थे कि अदर साइड में क्या है, और कभी कभी तो देखो हमारे जो क्लाइंट होते थे तो थोड़ा संदेह हो जाता था, क्लाइंट थोड़ा पढ़ा लिखा था। मैंने आई स्टार्टेड आर्गुइंग द केस ऑफ द अदर साइड, तो हमारे जूनियर को इसे चेक किया कि हमारे वकील सब बोल रहे हैं, अब सब उर्दू साइड का बोल रहे हैं, उसके पहले ना अब ऐसे लोगों को कहा तो मिल गया क्या वो समझ में नहीं आता है। तो उसी का केस बोल रहे हैं, इनका ये केस है, इनका ये केस है, इनके फेवर में ये डिसीजन है, बट मैंने डिसाइड देयर आर टू एक्सप्लेन इट and I and then I did my case and I won. ये सब मास्टर ऑफ फैक्ट मतलब क्या, अपने आप के फैक्ट से मास्टरी से कुछ नहीं होता। सारे फैक्ट सिचुएशन जो है आपके अदर साइड के उससे मास्टरी करो, एंड देन लॉज आर एप्लीकेबल ओनली ऑन फैक्ट। प्रोविजन ऑफ लॉ no. But which provision is applicable to which fact? For that, we have to become master of the fact, which the law is to be applied. I think it is enough for the day. Thank you very much.
Thank you so much, sir. Thank you for all your valuable experiences and all the input. And thank you so much for taking our time for us from your schedule. We'll be looking forward to having more of your presence in our future events. Now, as we move towards the end of the Student National Workshop, I call upon Ms. Ananya Bhardwaj ma'am to deliver the vote of thanks.
On behalf of the entire Amity Law School at Amity University, Jharkhand, I express my sincere thanks to Honorable Mr. Justice N.N. Tiwari, former Judge High Court of Jharkhand, who despite his hectic schedule spare time and graced the event as our guest of honor. Sir, your words of wisdom, a vast experience sharing of your tenure as an advocate and a judge, your immaculate knowledge on the subject and spirit has not only enlightened us, but has also motivated our students and faculty alike to stand and deliver. I really hope that we are going to be harmonious and receptive and learn the act of that. I must mention our deep sense of appreciation for our guest speaker for today, Advocate Bhavesh Kumar, Advocate High Court of Jharkhand. Sir, we are deeply indebted to you for your engagement with the workshop by providing a practical experience today, which will serve as a seed to nurture and train the young and fresh minds of law students not only at our institute but across the country. Without the support of our Honorable Vice Chancellor, Dr. Raman Kumar Jha, sir, our Director, Dr. Ajit Kumar Pandey, sir, and Registrar, Mr. Prabhakar Tripathi, sir, this event would have been a mere idea. Like always, our superior authorities have always motivated us to deliver the best, And sir, I assure you that this event is the result of our craving for the quest of knowledge. Our words would fall short to convey gratitude to our Assistant Director for Management and Law, Dr. Kasturi Ma'am, who has been a troubleshooter, humble mentor, and colleague and the best support possible for all academic guidance activities that are happening at law school. Ma'am, we owe you and attribute our work for your unfailing guidance. I thank all esteemed program leaders, faculty members of our department, and the organizing team for their unprecedented support and hard work to make this event a success. We express our gratefulness to the media team from the Amity School of Communication, IT team at Noida head office, and Ranchi for relaying our events live on YouTube. And without this support, this event would not have reached thousands across the country. I also thank the admission and digital team at Amity for promoting the event at all levels and platforms in electronic, print, and social media. Last but not the least, I would like to appreciate and thank the biggest contributor for organizing this event, the faculty convener of Moot Association, Mr. Vijay Sekhar sir, for conceiving this idea and executing on the same, and at the same time the enthusiastic students of the Moot team for today's event and volunteers who have worked day and night to make this event a success. Now I would like to call Vijay Sekhar sir, the faculty convener of Moot Association, Amity School of Law, Ms. Suhina Sinha, faculty member of the Moot Association, and the student members of the Moot Association, Nikhil, who is the convener, student convener, Rinal coordinator, Richa secretary, Srishti, Monisha, Ishan, Ritika, Anisha, Anubhav, Rohit, Shambhavi, and Aruni to kindly come up to the stage for a picture with the dignitaries. I will also request Kasturi ma'am to join us. I would also request our program leaders, Mayank sir and Keshav sir, to join the team. Thank you.